Brought to you by Wall Street Prison Consultants.
Hi, I'm Olivia, a custody advisor with Wall Street Prison Consultants. Today I'm going to explain mail fraud defenses and penalties. Mail fraud is defined as the use of the U.S. Postal Service in any criminal attempt to gain money or things of value. The original crime carries its own penalties in addition to the penalties involved with mail fraud, regardless of whether the original crime is tax fraud, healthcare fraud, or any other number of possible offenses. In order for a federal prosecutor to convict a defendant of 18 U.S.C. Section 1341, they have to prove the defendant made materially false representations or promises with the intent to defraud another, and use the mail to accomplish the fraud. Put simply, the prosecutor must prove beyond a reasonable doubt that all of the following: there was a scheme to commit fraud, the defendant used the mail to advance their plan, and the defendant had a specific intent to commit fraud. Federal Statute 18 U.S.C. 1342 includes in a mail fraud crime of the use of a fictitious name or address for a fraudulent scheme. Fraud schemes often involve multiple actors. It may be that a defendant simply placed a letter in the mail at the direction of their employer or another individual. If you can show you weren't a part of the fraudulent scheme itself, your facilitation of the scheme by mailing the letter is not enough to convict you of mail fraud. Courts have held that the mailed items need not be crucial or central to the fraudulent scheme and may be merely incidental. Still, your attorney will want to examine the government's evidence as to how the mailing of certain items played into the larger alleged fraud. It may be that the mailing is so unrelated to the purposes of the fraud itself that you can't be properly charged with mail fraud. The prosecution must prove its existence beyond a reasonable doubt to convict an individual of mail fraud. Therefore, if the defense can prove there is a lack of intent to commit fraud, the prosecution will not be able to make the charges stick. Mail fraud has a guilty mental state requirement that prosecutors must prove. Put simply, they have to show the defendant's specific intent was to defraud another. In other words, proving what they were thinking. Specific intent is not always easy to prove as it has to show a defendant's state of mind. The federal prosecutor must prove the defendant knew that the information relayed through the mail was false, and they intended the fraud victim to rely on that false information. A defendant's actual knowledge, their state of mind and intent, and materiality of statements are all important issues on where to plan a strategy of defense. Mail fraud does not refer to a specific type of fraudulent scheme. Rather, it is simply the crime of facilitating a fraudulent scheme or conduct by utilizing the U.S. mail. There are two elements to the federal crime of mail fraud: 1, devising or intending to devise a scheme to defraud, or performing specific fraudulent acts, and 2, using the mail for the specific purpose of executing the scheme of the fraudulent acts. For example, suppose Party A decides to defraud Party B by purporting to sell a piece of property to B which A does not own. In the course of convincing B to forward the purchase money, A sends several letters to B containing false deeds, etc., showing A's ownership of the property. B relies on the information in these letters and sends the money to A. A can be charged with defrauding B as to the property sale, but also with mail fraud as A utilized the mail for the purpose of attempting to execute the scheme. United States Code Section 1341 provides punishment for anyone involved in an attempt to fraud or swindle, who places in a post office mail any material to be delivered by the Postal Service. It also includes any commercial interstate carrier in an attempt to fraud or swindle. It states that a person will be imprisoned for up to 20 years. In addition, any violation that impacts a financial institution can lead to a prison sentence of up to 30 years and a fine up to $1 million or both. Now, let's talk about Wall Street Prison Consultants. Hiring Wall Street Prison Consultants when facing federal criminal charges can provide valuable support and guidance through a complex and intimidating process, and help defendants take advantage of programs offering substantial early release. Here's why someone in this situation might consider hiring them. While there's no shortage of criminal defense attorneys to represent defendants in the courtroom, most attorneys' knowledge of custody ends at the prison gates, leaving clients to fend for themselves after the judge renders sentencing. According to legal statistics, 97% of those charged are convicted, with thousands of white-collar defendants sentenced to federal prison each year, the majority being first-time offenders clueless what to expect upon entering custody. Wall Street's services begin long before a defendant even goes inside, and continues after release. Depending on when retained, they guide clients through indictment, trial, pleas, sentencing, and prison survival all the way through supervised release. By using their services, clients develop an edge when dealing with their lawyers. Wall Street takes the mystery out of the judicial court process by educating clients with easy-to-understand step-by-step explanations on federal criminal statutes, indictments, and how it applies to them, so they can make educated decisions about their case and understand the ramifications of a criminal trial versus taking a plea agreement. As I'm sure you're aware, prisons can be dangerous places, and having knowledge about prison policies, early release programs, medical care, inmate jobs, dealing with gangs, staff interactions, and the basic politics surrounding incarceration are the keys to surviving successfully and returning home safely. Many defendants are often confused listening to lawyers, friends, and family members about what will happen to them, and whether hiring a prison survival consultant is helpful at all. While others may have opinions, they are typically not qualified opinions. And once sentenced, it's the defendant's freedom and safety at stake, with everyone else's well-meaning opinions being worthless. When going to prison, knowledge is key, and hiring a prison consultant with facts instead of uninformed viewpoints can be the difference between early release and spending unnecessary time in custody. Wall Street prison consultants have detailed knowledge of both the federal legal system and the inner workings of the federal prison system. Their expertise can demystify the process for defendants and their families and help them prepare for what lies ahead by offering strategies and advice on how to reduce sentencing length through various legal channels and inmate programs, focusing on aspects legal teams might overlook. If a prison sentence is unavoidable, Wall Street prepares defendants for the realities of prison life, teaches them survival tactics, and helps with the emotional transition from freedom to confinement, as well as securing designation to a preferred facility that meets an inmate's needs and aligns with their specific security level or health requirements. Wall Street offers support in planning for life after release, including supervised release requirements and re-entry into society, and doesn't make false promises, but provide a realistic view of the situation and what can be done to mitigate it. While they are not lawyers, they often work in conjunction with legal teams to make sure that all aspects of the defendant's situation are being considered and offer more personalized and continuous support compared to a legal team, especially during the post-trial and imprisonment stages. In essence, they can provide comprehensive support tailored to the unique needs and challenges faced by someone charged with a federal crime, and help them navigate through both the legal and prison systems. It's a specialized service that can add an extra layer of support and guidance that complements the legal defense, but doesn't replace the need for competent legal representation. For more information, contact the director and founder of Wall Street Prison Consultants, Larry Levine, at 213-948-1069, or by email at help@wallstreetprisonconsultants.com. Or visit us on the web at wallstreetprisonconsultants.com.